everyone. Hello, hope you're good, hope you're fine. So today we are looking at understanding terminologies used in court proceedings. Now, in court proceedings, sometimes when the court adjourns or when a matter is listed a particular thing, and for new lawyers who don't understand, they feel, what is this for? They don't understand what to do. So this video is especially for young lawyers who are new to the system so that they'll be able to understand what the court means as per each terminology that is being used. So, if you're new to this channel, this is Lawyers Info Hub. Please do hit the subscribe button, subscribe, share this video because I know that you will learn from it. So, the first one I'm going to talk about is when a matter is adjourned for mention. Most of the times, a file is being given to you and they say it's for mention. What is in your what comes to your mind? What will you do in court? Now, when a matter is for mention, most times it's coming up for the first time, it's just for the court to mention it. And when it's mentioned, this is when the court will look at have the parties been served, are they within the prescribed time required by provided by the rules? Has the time elapsed? Are they supposed to have filed their defense or whatever response they are supposed to file? So these are things the court will ask you, and if the time allotted to the defendant, for example, has elapsed, now the court will not ask you, what do you want to do? What is the next step? You know. Now, depending on the type of matter, there are things to do from one step to the other. If you maybe for summary judgment, and if you need to go for case management conference, depending on the type of suit or the matter you have in court, will determine the next step you are to take. Now, when a matter is listed for further mention, what does it mean? Further mention is maybe it has come up for the first time, now it's coming up again. Now, when you get to court, the court will also look at the fact, look at if there were issues of service, has it been rectified? Was hearing notice issued? Has it been rectified? Under further mention, the court can even take an application. Maybe you have an application for subsistence service, the court can hear you just to ensure that the processes are duly served on the other party. So when you say when you hear that the matter is for further mention, um, every proceeding is a serious proceeding, so you have to also prepare. So, but we've not gotten to the main hearing of the appeal of the suit, just about the preliminaries, trying to ensure the parties have been served, hearing notices have been issued. If there are applications, it can be taken when a matter is listed for further mention. When a matter is listed for report of service, that means the court wants you to be, to confirm that you have served. Where a matter sometimes is listed for mention and the party comes and the court asks about service and it is confirmed that the proof of service is not before the court. The court can adjourn for report of service. This is where you report that service has been effected. The proof of service is before the court, and the court might ask, what is the modus of service, which you can explain to the court. Now, when a matter is listed for compulsory conference, depending on your jurisdiction, you can call it CMC. This is where this is preceded by filing of Form 17 and 18. This form, you make an application to the court. Once the court approves the application, you file this form. What is the essence of the case management conference? The purport of case management conference is where parties can come together and see, are there contentious applications? Are they okay? What are my defense? Are there what is your what are my claims? What are the defenses? What are the documents? This is where parties come together, can say, okay, under case management conference, can we resolve this issue? Can there be room for amicable settlement? So sometimes under case management conference, most judges will refer the matters to mediation at the level of sometimes they multi-door courthouse, depending on your jurisdiction. But I know that this is equivalent in many jurisdictions. This is where court is okay, do both, see and see if you can settle. And during case management conference, as provided by the rules, the parties should come. Parties should be or to come in to court where the party court can ask questions. These things is not something we can iron out. The court would like to look at it, streamline the issues, and let it not be that parties came together and they were not able to resolve the issues. And this is where are there documents you require, or if the other parties notice to produce. These are just where like a well, I call it the the preparation period. That's what I call it. So, case management when both parties come together and say, okay, these are the documents, these are my claims, and there are ways we can resolve it, issues of interrogatories, other things, maybe under case management conference, sometimes if it's issue of land, they might ask that composite plan be done. So these are the time parties will come together and see how we can resolve and put our house in order. So if parties are able to settle, when the court refers them to the multi-door courthouse and they are able to settle, the matter is really resolved. But if parties are not able, even when the court sends the file to or refers the file to the multi-door courthouse and the parties go and they come back to say, my lord, we are not able to resolve the matter, we proceed. Now, in other jurisdictions, when a matter at the end of the case management conference, the judge will transfer the file to a trial judge, depending on jurisdiction. Sometimes it doesn't happen like that in other jurisdictions. The court, once they close the composite conference, they move to trial. So it's over the case management conference, all interlocutory applications should be taken so that when the file moves to a trial judge, the trial judge will just move to trial. So during case management conference, all interlocutory applications should be resolved, issues of amendment, pleadings, anything you want to do, it is within that window you're supposed to do. That is what the rules project, that's what the rules have in mind, or what is the intent of the rules. So during the case management, you put your house in order, sort out everything so that the trial will go on seamlessly without any obstruction of objection here and there, amendment here and there, and to delay the will of justice. So when the court adjourns for CMC, you understand that it's case management conference, depending on what is it called in your jurisdiction. Now, sometimes the court can adjourn for motion. Or maybe there's an outstanding motion, the court can adjourn for PO, hearing of preliminary objection. The court can adjourn for, can just say hearing, which is hearing of an application. But sometimes in a petition, when the court adjourns for hearing, sometimes it is trial. So it depends on what the matter is all about. You have to be very honest to know what happened at the last date and what is the court referring to. That is why it's important for proper endorsement of a file. I've done a video on how to endorse a file. Please check my channel and check out that video. Many people don't endorse their file very well. That's why when they get to court, they are confused as to what happened at the previous proceedings, and you see the court trying to bring them along, and sometimes the judge is like annoyed, like don't even know why you are in court. So when the court adjourns for hearing of an application, maybe there's a motion, there's an application, pending application for anything, amendment, the issue of jurisdiction, or the objection of the jurisdiction, whatever it is, the court will adjourn for the hearing of that motion. And when you know it's for hearing of that motion, when you announce your appearance, depending on the party you are, this is the business of the day. So the court, adjusts for particular things to help it, for a smooth process or a smooth court proceeding. Because if the court does not adjourn for anything, you see that when they come, like, where are we? But the court will always adjourn for something. If you check the records of the issue, that the court will always adjourn for something. Is it for hearing of motion? Is it for further directive? Now, sometimes the court can adjourn for further directive. It means there are things that are supposed to be done, or there are directives given for compliance, or the matter is still not yet right for hearing. Other things will be done, maybe issuance of a hearing notice, filing here, maybe there's an order to be effected. So further directive also means something has to be done. There is the directive given to be effected for compliance. So when the court adjourns for trial, I mean now for the parties to open their case, and the claimant will start by calling witnesses, adopting their witnesses on oath, tendering their documents, and on the day there's cross-examination, defense will open, and at the end of the day, trial is concluded. Now, sometimes trial is not concluded in one sitting, and court can keep adjourning for trial until the end of trial. After which, court can now adjourn for adoption of the final written addresses. I know once at that stage that the case is almost over, after which the court can now adjourn for judgment. So there are terminologies used, and as a newbie and as a new lawyer who does not understand these terminologies, you might feel lost when they say the matter is for this, the matter is for that. So understanding these terminologies helps you for to prepare well and have confidence when you're in court. Sometimes when a file is being given to you, you don't even know what is coming up for you. You're lost, and there is that confidence, you not like that confidence to address the court. But when you know what the matter is all about, what the court has done for, if it's for application, you have read the application, you have understood it, you can argue it, so this is what also happened in the appellate court. Is it for hearing, for motions? Is it for the hearing of that plea? So you must know what the court is, what it has been, the court has adjourned for, and what is the business of the day. When you lose track of the business of the day in court, you lose the confidence because you will still be, looking at flipping your fight to know what is the next thing, what happened. So when you're not in court, you can reach out to the other counsel to say, please, what is in court? Or make application to search the file. Sometimes people come to court so that their matter has been struck out. They'll be wondering what happened. People come to court and see that cost was awarded to them because they didn't know what happened at the last adjourned date. They will come and they know that cost, and the other counsel is asking of payment of the cost, and that the court should know that the right of audience, about the withdrawal and all that. So we must know what the next day is for. Not just the Lord I see for adjournment, so that the court will ask you adjournment for what? At this point, see, many lawyers don't even know why they're asking for adjournment. Are you holding brief for someone? You must know what the matter is for. And even if you're asking for adjournment, the court will ask you adjournment for what? So this question, even senior lawyers, junior lawyers, most times they are caught up with this question. So you must always know what is the stage. And during the law school training, they are being taught preparation of trial. That's the way the trial goes. It's more like a map, how you draw the trial plan, is still in use in practice. So you must have the trial plan, you must know how is my matter moving, and as it's moving as a counsel, who is smart, who is excellent. You must move with the trend and know what to do at every point of time. Are you to, to carry out the orders of court? Are you to inform this? Are you to issue or process the issuance of the hearing notice? There are things that happens because of the matter. You must be abreast with your facts, you must be abreast with your case, and you must know the mind of the court. So don't go to court unprepared, not knowing what the next day is for. Don't just go for adjournment. What are you adjourning for? What is the court adjourning for? And when you don't ask, you can't say, why am I adjourning for what? You should be able to know what is coming next. So understanding these terminologies is key in having a seamless practice. If you are yet to hit the subscribe button, please do hit the subscribe button. Subscribe to this channel. Share this video to your friends. We create content to help lawyers get more knowledge, have knowledge at the tip of their finger. We are supporting the growth of the legal education in Nigeria, in Africa, and globally. So we are here for you. If you have questions, drop them on the comment section. You will receive access to them. Thank you. I want to see your comments. You have experience in these issues, just drop it, and you will be gladly welcome. Do take care of yourself and know that you can always be the best. Take care of yourself.